Well, this is breaking news and a loss for the Trump administration I can get behind. 2-1, a 3-judge panel of the Appellate Court for the D.C. District Court in the federal court in District of Columbia has ruled against the Trump administration and their attempt to have the temporary restraining order placed by Judge Boasberg, the Chief Judge of the District Court, have it lifted to allow them to continue to deport undocumented people from Venezuela and deport them to El Salvador for them to be tortured. That is not happening right now, at least during the appellate process, according to the 2 judges who voted for it. Now, let me just do a little procedure here. There's no one opinion. There's 2 concurrences, 2 concurring opinions, one by Judge Millett, one by Judge Henderson, a Bush appointee and an Obama appointee, with a dissent by a Trump appointee, Walker. But in a 2-1, the majority agreed that the injunction should not be lifted during this temporary period while the appellate process is going on, because they thought it was more likely than not that the Trump administration is going to lose on the merits, that this was a phony declaration of war power. Everybody agrees that if there is a war, the president, as the head of the executive branch, is given tremendous and a wide berth, tremendous authority and superpowers. But when the war is over, or never really existed, and a predatory incursion, as that term is used in the statute, or an invasion is also not present, he doesn't get the war powers. He has them for as long as the war is on, and he loses them as soon as it's over. And whether it's over or the war is on, or whether there's a predatory incursion or invasion, both judges, Millett and Henderson, said that's for judges to interpret. That is constitutional analysis or interpretive analysis, which is proper for a federal court. In fact, it's mandated that they exercise their jurisdiction in those areas. The 2 judges got to their decision by taking different roads and different routes, but they ended up in the same place. I'm going to cover it right here on Legal AF. I covered earlier the actual oral argument 2 days ago, in which I thought it was going to be a 2-1 decision. Millett led the oral argument. She ripped the government and Drew Ensign, the lawyer for the Department of Justice, a new one. That's a legal term you've learned here on Legal AF. She's the one, and the headline was, Judge says Nazis given more due process than what has been given or afforded by the Trump administration. She meant likely Nazis living in America during World War II, during that hysteria, were still given due process. And Millett put in her decision, in her concurrence, I'll read to you from it in a minute, that we are at the intersection, an important intersection of due process rights under the Fifth Amendment and the Alien Enemies Act. And she's concerned that the Trump administration has completely ignored the due process obligations. They never talk about the constitutional obligations to be confronted, to have lawyers, and to have a neutral third party decide the issues in an adversarial proceeding. That's due process. Why, all the judges in the majority are questioning, why do we have to do this so quickly? Why do they have to be deported to El Salvador? Why can't they just be held in detention? Nobody, just to be clear, nobody, Judge Boasberg, the judge, the appellate court, nobody is saying that the Trump administration can't process these people and deport them if they have the evidence through normal immigration channels, with an immigration judge, with due process. You can even keep them in Guantanamo Bay if you want to in the meantime. You just can't, in the middle of the night, shackle them all together and put them off to an El Salvadorian prison where over 300 people have died in the last year from quote-unquote natural causes, which is the El Salvadorian way, at least the government's way of saying we beat them to death. That's what the record shows. That was recited by Henderson and Millett in their concurrences. So what's the rush, everybody? You can retain them, you can detain them, you can put them in internment camps, in concentration camps, you can deport them through the immigration. Why do we have to shackle them together under a phony declaration or proclamation of war? And whether we're at war with Venezuela, which is news to everybody, including apparently Congress, where's the Congressional Declaration of War? Where is it? That only shows you this gap between Donald Trump's proclamation last Friday and the lack, listen for it, the lack of declaration of war by Congress only reinforces the appellate court's decision-making. They acknowledge the superpowers of a president during war, but also acknowledge when that war is over, the superpowers disappear, right? That's it, kryptonite, it's over. So let me just read to you from how Henderson got to her place, and then I'll read to you on how Millett got to her place, and then we'll kind of tie it all together. I'll give you the summary. Henderson's position is that the appellate court does have jurisdiction because even though this is a temporary restraining order application related to a TRO, which normally appellate courts don't have jurisdiction until it moves up the food chain to preliminary injunction, she thinks that because of the foreign powers issue and the negotiations with foreign powers, that tips it over into having jurisdiction. Judge Millett doesn't believe there's jurisdiction, but she said, because 2 out of my 3 up here think there is, I will then comment on it. They all walk through, Millett and Henderson, the history of the Alien Enemies Act, how it came to be in 1798, why the other 2 brothers and sisters for the Alien Enemies Act, the Alien Friends Act and the Alien Sedition Act, no longer exist. Why they were probably unconstitutional, why this is the only one remaining, and yet it is tied to a proclamation by a president and a declaration of war or the existence of an enemy incursion or invasion. They also commented that the states used to argue that this immigration border problem was effectively an invasion and that it should be declared. But that's a political question. Courts are not going to declare a war for Congress, but they're also going to recognize when a war has not been declared and define that the war powers, and this is a war power, aren't being properly exercised. So both Millett and Henderson said, in effect, constitutional analysis of whether this is constitutional and interpretive analysis, that's for federal judges. That's what we get paid to do. That's in our ken or remit. The Trump administration, by opposition, argue that there is no ability to review war powers, even if they've been falsely declared. And under the leading case of Ludecky, cited by both Henderson and Millett, a 1953 case of the United States Supreme Court, that was about a federal judge being able to determine whether a war was still going on with Germany at the time the Alien Enemies Act was being used. Because if the war wasn't still going on, then the president lost that superpower. Get it? Ludecky is the leading case. Everybody agrees to that. Now, Millett took special delight, I would assume, in taking the Trump administration to task. They said, what she said was, what is intolerable is your arguing on one hand for the last 10 days that Judge Boasberg did not issue any type of injunction because it was oral in nature and only declared during a hearing, which in my book and under the case law is an injunction. But you can't argue out of one side of your mouth that it's not an injunction because it was done orally and then come to this court and argue that you need a temporary restraining order because the thing that you don't think is an injunction is really an injunction. That is intolerable. And so the only dissenter in all of this is Judge Walker, a Trump appointee, a very young judge, by the way. And his only main argument was really not on the substance. It was on, I really think this is a habeas corpus petition, which is a unique writ where a prisoner wants to get released and brought into court for an argument. And he says it's habeas corpus and it really should have been done in Texas where they were processed. Why are you in D.C.? And they said, we dropped our habeas corpus. We're here about whether the Alien Enemies Act is being properly applied by federal agencies. They all exist in D.C. That's why we're here. It was sort of weak tea, if you want my opinion. I think you do. You're here. About Judge Walker. So to answer the question, 2 concurrences can make a decision. Even if they get there by different roads and different analyses and jurisprudential underpinnings, they got to the same place. Request by the Trump administration to block the temporary restraining order, allow them to immediately deport under the Alien Enemies Act is denied. Case continues at the Boasberg trial court level. He's now sitting on a couple of decisions. He's already in the last 3 days renewed the temporary restraining order, refusing to vacate it under the Trump administration arguments. So it's in place. It will then move to a preliminary injunction briefing, which will head out over the next week or 2. And then he's going to make his decision, I'm sure, to keep the preliminary injunction in place. Then that can be appealed to the United States Supreme Court. Underneath that, the judge is trying to get to the bottom of whether there's been a contempt of court by the Trump administration for violating his orders to stop deporting people starting at 6:30, between 6:30 and 7:30, a willful violation, a defiant violation of his order. Their argument on the Trump side is the injunction didn't happen until you entered the order, the minute order on the docket. The minute order of the docket's for the public. Everybody in the courtroom, the parties knew what the injunction was. So their argument about it, the injunction was 7:30, not 6:30, doesn't fly. So the judge is trying to get to the bottom of that with fact finding. He's going to make a ruling on that. That'll be appealable as well. And that all kind of comes together. Within 2 weeks or less, we'll be at the United States Supreme Court level. Because I do believe through Chief Justice Roberts, there's at least 4 votes. That's what you need to take this matter up on a writ. Now, whether there's 5 votes to vote for Donald Trump, that I'm not so sure about. I think it probably goes down 5-4, 6-3 against Trump, but we'll continue to follow it right here on Legal AF with all those moving parts. Follow me, Michael Popok, here over on the Midas Touch Network and on Legal AF, the podcast. So you can get Popok and Legal AF in variations on a theme. And a new show I'm doing on Tuesday nights, a new podcast called Popok Live on the Midas Touch Network at 8 p.m. Eastern Time over on their YouTube channel. So till my next reporting, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.